Good day, Mr. Hacharan. Today, I will be analyzing on whether the maxim equity will not perfect an imperfect gift and equity will not exist a volunteer contradict a settler's intentions. It is the general rule in equity that, in order to create a valid trust, the three certainties must be fulfilled when the settler purports to declare the trust and for the legal title in the trust, property to be vested in the trustees. Once a trust has been fully constituted, beneficiaries have immediate equitable interest and can compel trustees to perform the trust obligation by virtue of their interest as beneficiaries. However, there are situations where the trust has not been properly construed due to the absence of the certainties, but the claimant argued that an effective trust has been created. The first situation is when the intended beneficiaries argues that the incomplete constituted trust is valid as there were good conscience to give effect provided by the settler. The second situation is when the settler intend to create a trust but either change their minds or fails to give effect to the transfer of their property to the intended recipient. The law regulating the constitution of trust and gift is governed by two equitable maxims. Firstly, if the settler has failed to constitute a trust, equity will not do so for him, according to the equitable maxim that equity will not perfect an imperfect gift. Secondly, the would-be beneficiaries under incompletely constituted trust have no rights unless they have provided consideration which is in accordance with another equitable maxim that equity will not exist a volunteer. The fundamental rule of the English law in the creation of express trust is that equity will not permit an action which was intended to be validated by implying it to be a trust instead. The case of Murray and Lotz deeply concerns every effort rule and the constitution of trust. In this case, Medley assigned 50 shares by voluntary deed to Lott upon trust for Murray's benefit. However, no transfer of the shares was registered in the company's book following formalities for transferring shares. Because of such failures to observe the formalities required, the trust is incompletely constituted. The classic statement that the court established to render a voluntary settlement valid, the settler must have done everything which was necessary to be done to transfer the property. Lord Justice Turner set out three processes that equity would recognize as establishing a valid gift. These were an outright transfer of the legal title to the beneficiary, an outright transfer to trustee to hold on trust for the beneficiary, and a self-declaration of trust. Lord Justice Turner goes further by stating that failure to transfer property by one of these methods will not be construed as a successful attempt. Hence, whether the maxims contradict a settler intention, at first glance, it may seem that the maxim equity will not perfect an imperfect gift and equity will not exist a volunteer emphasize the importance of adhering to legal formalities and requirements for a gift to be considered valid and enforceable. However, if a donor has the clear intention to make a gift or create a trust, shouldn't equity exist in carrying out that intention, even if there are technical deficiency in the transfer or declaration? Upon closer examination, the strict application of the maxims may contradict the settler's intention, as the maxim disregards or undermines the settler intention due to technicalities or failure to meet specific legal requirements. If a settler verbally expresses their intention to give a valuable item to someone but fails to complete the necessary formalities, such as delivery or documentation, equity may refuse to enforce the gift. In such cases, the settler's intentions is sidelined, and the intended recipient may be unjustly deprived of their rightful entitlement. Furthermore, the maxim does not adequately account for unforeseen circumstances that may prevent the settler from completing the gift. If a settler unexpectedly passes away before finalizing the transfer, equity's strict adherence to the maxim may deny the intended recipient a gift. This outcome contradicts the settler's presumed intention and may frustrate their desire to benefit the intended recipient. However, equity will not perfect an imperfect gift is one of the maxims of equity that embodies the general principles that evolve in the Court of Chancery. There are not strict rules which should be applied in every case, but rather general guidelines which provide the ways of exercising equitable jurisdiction. It is also worth noting that the maxims is not absolute and subject to certain exceptions. There are 5 exceptions which aim to prevent unjust enrichment or unconscionable conduct by recognizing equitable rights or obligations based on the donor's intentions and actions. The first exception is where the donor has done everything necessary. The case of Rose modified the outline rigid approach in terms that a disposition in equity will be completely constituted where the transferor has done everything within his own power to transfer property to the transferee. The case of Rose established the principle that if the donor has done everything that can be expected of him to transfer the legal title, but the effective transfer is delayed by the routine operation of law, the gift is effective despite the lack of a valid transfer of title. Rose applied to shares but, in principle, can apply to any transfer where legal formalities take time to complete. It is routinely applied to land transfers, which are invariably deemed to be effective in equity from the moment contracts are exchanged, despite the lack of transfer of legal title. Thus, the principal layout in this case gives an exception that when the donor has done everything in their power, equitable title is passed to one. In T. Choidram International SA and Pagarani, the scope of the maxim was again widened as Lord Brown Wilkinson held that, although equity will not exist a volunteer, it will not strive officiously to defeat a gift. This was justified with the fact that there is no distinction between a donor declaring himself to be a sole trustee and a donor declaring himself to be one of the trustees for the donee. In both cases, the donor's conscience is affected, and it would be unconscionable and contrary to the principles of equity to allow the donor to resile from the gift. On these grounds, it could be asserted that a supplementary mode of transfer was added to the 3 exclusive modes declared in Milroy and Lodge, which is the declaration of self and others as trustees where no transfer is needed because conscience is affected. The deviation in the Pagarani case from the precedent set in Milroy and Lodge and Rose can be justified based on the unique circumstances of the case, but the same cannot be said for the decision in Pennington and Wei. The Court of Appeal upheld the gift contrary to the principle in Rose, notwithstanding that the fact that the donor has not done everything in his power to transfer the shares to a donee. Lord Justice Adams stated that there was a clear finding to make an immediate gift and that an apparently incomplete gift is to be treated as completely constituted trust if the donor will not be permitted to change his mind because it would be unconscionable to do so. Lord Justice Arden did not provide a comprehensive list of factors to assess the unconscionability of recall of gift making, as each case must depend on the evaluation of all relevant considerations. Following the argument of expanding the scope of Milroy and Lodge rule, it may be argued that declaration of trust where the transfer is inadequate but the conscience of the transfer is affected constitute an additional possibility to transfer beneficial interest in the property. However, unconscionability is difficult to justify on the policy ground of fairness as it is outweighed by the uncertainty, unpredictability, and arbitrariness encouraged through its operation. Moving on, perfection through fortuitous vesting of legal title in trustee. The controversial exception which can be seen in the case of Rarely Will Trust. In this case, the intended trustee did not obtain the property from the particularly intended donor, but received the property by acting as a trustee of the other testatrix. The court held that, although the intended donor did not complete the transfer of the legal title of the gift to a trustee, as the transfer was still completed in another capacity, thus, the trustee was holding the legal title of the property on trust for the intended donor. However, this principle has its weaknesses. On one hand, this has never been applied, but on the other hand, it has never been overruled either. Therefore, it is uncertain whether a claim under release will uphold. The next exception is donatio motis causa. Donatio motis causa is an inter vivos transfer of property made by a donor while considering death, with the condition that the gift will be perfected upon death. This exception is utilized in circumstances where a person contemplates their imminent death and wishes to leave their property to another person, but does not have time to execute a will. A donatio motis causa has been described by Justice Buckley in Re Beaumont as a singular form of gift, something between an unconditional inter vivos gift and a gift on death. It is a transfer of property inter vivos, but conditional on death. The requirements of donatio motis causa are set out in the leading case of Sand and Hadley by Lord Justice Knowles. Firstly, the gift must be made in contemplation of death. In the case of Recraven Estates, it was stated that the donor must contemplate his death within the near future, what may be called death for some reason believed to be impending. The donor must not, however, contemplate immediate death or be on his deathbed when he makes the gift. Secondly, the donor must intend the gift to take effect and become absolutely only upon their death. In Recraven Estates, it was stated that there must be a clear intention to give, but to give only if the donor dies. The gift is therefore capable of being revoked at any time before death. Thirdly, there must be delivery of the subject matter of the gift or title to it, which amounts to a parting with dominion, possession, or control. In Cain and Moon, a daughter gave a deposit note to her mother for safekeeping. 2 years later, while the daughter was seriously ill, she told her mother that the note was for her if she died. The court ruled this to be a valid donatio motis causa, as it was not required for the mother to return the note and for the daughter to redeliver it upon expressing her intention. The doctrine of strong and bird has traditionally been characterized as an exception to the principle that equity will not perfect an imperfect gift. The rule in Strong and Bird dictates that where a deceased person intended to make a gift of property without making a complete gift, if the person is named as the executor of the deceased estate, the gift is deemed to have been completed. There are 3 requirements for the rule to operate. Firstly, there must be an intention to make an immediate gift. In a practical way, it is essential to determine whether the donor has the time to execute the will. If the donor has no time to execute the will, then the contemplation of death is sufficiently proved. Secondly, the intention must continue until death. The intention shall be continuous and uninterrupted throughout the remainder of the donor's life. Lastly, the donor must obtain legal title in the property in the capacity of either as executor or administrator. In the case of Stewart, the rule in Strong and Bird was extended to complete and incomplete gift, which is any type of property, but not just debt to the person who subsequently becomes the donor's executor. In James, the rule in Strong and Bird was extended to appointment of a debtor as administrator of creditor's estate. In this case, the court ruled that if there is a continuous intention of the creditor to give the property to the donee until death, and the donee is then appointed as the administrators of the donor, then the effect will be the same as the debtor being appointed as executor under the will. However, there exists considerable debate about whether this rule should be applied to administrators at all. This can be seen as harming the property, as the beneficiary has not provided sufficient consideration of benefiting the property. Furthermore, the rule in Strong and Bird had no application to the case where the donor had a mere intention to make a gift in the future, as in the case of referendum. The rule in Strong and Bird was followed by the Malaysian case Rashid Hassan bin Abdullah Al Jofri disease. The plaintiff, who was one of the executors of the deceased estate, claimed that a piece of land had been gifted to him by the deceased during their lifetime. The plaintiff relied on the principle in Strong and Bird, arguing that the intention to make a gift to an executor remains valid upon the testator's death. However, the court dismissed the claim, stating that the plaintiff failed to prove a valid gift. The court held that, to succeed, the plaintiff needed to demonstrate the deceased's immediate intention to give the land, which persisted until their death. The rule in Strong and Bird was subsequently applied in the case of Lee Hun Ki and Yeo Seng Huat. The last exception is proprietary estoppel. Proprietary estoppel is a further exception to the rule that equity will not perfect an imperfect gift. This exception aims to compensate a claimant who has suffered a detriment caused by the defendant. As in the case of Pascal and Turner, where a man left his wife and said she can keep the house, leading her to maintain and repair the house. In the eyes of the law, the ex-partner who left is the legal owner, but because the wife acted to her detriment, she was entitled to some compensation. The law employs a broad construction of what type of conduct is required to succeed in claiming a proprietary estoppel. In Rebasham, mere oral evidence of a gift of a house by the daughter's stepfather was enough for a proprietary estoppel to be found, the detriment coming from caring for the stepfather when he was ill. In the Malaysian case Baustat Trading and Arab Malaysian Merchant Bank Berhad, Justice of Court of Appeal Gopal Sriram said that the detriment is not prerequisite for proprietary estoppel to arise. Under Malaysian law, B may be entitled to have an imperfect transfer perfected if B could show that A had made representation which she intended to be relied upon, and which in fact as relied upon by B, where the circumstances of the case renders it unconceivable for A to go back on the representation. In conclusion, the strict application of the maxims equity will not perfect an imperfect gift and equity will not exist a volunteer in the context of trust constitution and gift creation pose challenges when it comes to upholding a settlor's true intention. While these maxims serve the purpose of maintaining legal certainty and preventing unjust enrichment, they may contradict the settlor's intention and undermine the broader principles of fairness and justice. Exceptions to these maxims have been developed to address specific circumstances where the settlor's intention should be upheld, even if technical deficiency exists. These exceptions include cases where the settlor has done everything necessary, fortuitous vesting of legal title in trustee, donatio motis causa, the rule in Strong and Bird, and proprietary estoppel. These exceptions aim to prevent unjust enrichment and unconceivable conduct by recognizing equitable rights or obligations based on the donor's intention and actions. However, the application of some of these exceptions may vary, and their scope is not always clear, and this may leading to uncertainty in law. Hence, equity should strive to find a balance that upholds the settlor's intentions but also maintaining legal order. While legal formalities and requirements are important for maintaining legal order, equity should also consider a settlor's true intention and the principles of fairness and justice. Striking a balance between legal certainty and the settlor's intentions would ensure that the maxims are applied in a manner that upholds the settlor's intention while still maintaining legal order. That's all for my video presentation. Thank you.